Okay, I'm going to go ahead and get started. Good afternoon, everyone. My name is Jennifer Mondino. I'm Director of Legal Programs with the Time's Up Legal Defense Fund at the National Women's Law Center, and I am so excited to welcome you all today to our webinar on technology-assisted sex harassment. This is a presentation that's brought to you by the Time's Up Legal Defense Fund and the Legal Network for Gender Equity. And specifically today, we're going to introduce the issues of technology-assisted sex harassment, including how this type of harassment presents and is experienced by survivors, and give some guidance for attorneys about how to represent individuals who are facing this type of abuse. In this time of global pandemic, when so many of us are relying on technology to stay connected, the issue of sexual harassment and sexual abuse through technology has been getting a great deal of attention in the media. I was scrolling through the New York Times online just an hour ago, and half of the most popular stories have to do with different types of abuse that have happened recently using technology. But as our expert presenters will probably tell you today, this kind of abuse is neither rare nor new. It is really something that we have been hearing about and hear about very often at the Time's Up Legal Defense Fund. We've been hearing about these issues since the start of the fund, well before the start of the pandemic. So we are grateful, so grateful to our volunteers in the Legal Network for Gender Equity for everything that you all do to help us combat sex discrimination, including sex harassment in the workplace, and also for taking time today to learn about these really important issues about how technology is used to perpetuate this kind of harassment and abuse. Thank you also to our really fantastic presenters, Carrie Goldberg, Dr. Marianne Franks, Jessica Morak, Erica Olson, for all their wisdom and the time that they put into preparing this presentation. I'm not going to describe to you their really interesting backgrounds and expertise, but their biographies are included in the CLE materials that were distributed before the presentation today. So you all should take a look at it and read about them. They're a really fascinating group of people. I'm so excited to bring them to you today. And thank you also, a huge thank you to the law firm of Holwell, Schuster and Goldberg, LLP, for working with us to provide CLE credit for this presentation. They are doing that pro bono, and we really appreciate all the effort that they put into making it possible to have CLE credit for participating in this presentation today. One quick word about the CLE credit. You have to attend the entire presentation to get the credit, and at a few times during the presentation, I'm going to read out some codes that you will need to take down. You're going to need those codes later to be able to get your CLE credit. So pay attention for those codes. There's going to be one around the midpoint and one at the end. Another note for today, you all participants can see us, we can't see you, but you can communicate with us through the chat function. So if there are issues, you can let us know that. Also, if you have questions for our presenters, send them to us in the chat function. I want to give our presenters time to give you the substance of what we planned today, but we are going to leave a good amount of time, about 20 minutes at the end, for Q&A. So if folks have questions, send them to us in the chat, and we will do our best to address them at the end of the presentation. So with that, I'm going to move into the first of the topics on the agenda. There's an agenda in the CLE materials also, if folks want to look and see where we are in the presentation. First, we were going to talk about generally how technology-assisted sex harassment and related sexual violence presents. What does this mean, and how is it experienced by survivors? So first, I was going to turn it over to Dr. Franks. Marianne, can you start us off just explaining what do we mean by technology-assisted sex harassment? What is this all about?
Thanks, Jennifer. So probably the simplest definition is that it's the use of technology to engage in unwanted sexual conduct or to single out individuals based on their gender for negative treatment. And that can include any number of things, including sexual propositions. It can include distributing private information without consent. It can include threats. It can include stalking. And these are all kinds of behaviors that probably many of the people watching are very familiar with as instances or examples of sexual discrimination or sexual harassment. But the key to trying to get a handle on the technology facilitated aspect of this is to consider the ways that technology makes this both easier for perpetrators to engage in and much harder for victims to escape. So when we say technology facilitated, we mean using things like email or social media or websites or hidden cameras or images of people, all kinds of different ways that technology, which can be used for any number of innocuous and good purposes, is appropriated for the use of abusing someone or exploiting them in some kind of way. And what that does, of course, is makes it easier in some ways for people to abuse other people without ever having to own up to the fact that they're doing it. The possibilities for anonymization are tremendous through technology. And it's much easier to gain other people, that is to say, aggregate the abuse by using social media or leveraging technology in a way that helps other people join the abuse. And because of the way that technology often propagates this kind of abuse, it can be harder for a victim to ever escape it. That is, you can leave the workplace, you can leave the school, but if there are search engine results that display your naked photos, or if there are websites set up to harass you, or if you're getting a constant stream of social media messages or emails, you can never escape the abuse in some ways. And there's often a permanent record of what is going on that is very difficult for a victim to leave behind. At the same time, it makes it very difficult for any target of this abuse to use technology in the ways that they would normally get to, because all of us now are dependent on technology in so many ways. So this abuse makes it so that these very tools that people rely on are turned against survivors and victims of this, so that email becomes a hostile type of a communication. Social media becomes a nightmare. And it adds a layer of complexity to getting help, because very often, in addition to the fact that there's a lack of sympathy and understanding for many forms of sex harassment as is, there is on top of that often a lack of familiarity and understanding of what technology does to make this worse. And there has been for a long time a sense that survivors or targets should simply leave the internet or turn off their computers or simply avoid technology as a way of avoiding the abuse. So all of that complicates the paths for help that any victim is going to be able to use. Now, one dark, possibly silver lining part of the pandemic has been that everyone who's lucky enough to have internet access has been sort of forced to go online for any number of things, for work, for school, for socialization. And that means that unfortunately there are lots more opportunities for people to be abused and exploited. So it's really kind of made that harder for everyone. But the slight silver lining here is that more people now understand the extent to which technology is completely integrated in our lives and that we can't escape it, and that it has never been a satisfactory response to say, turn off your computer. But if it, even those who thought that it was an appropriate response are now coming to realize that there is no escaping from technology. So in some ways, there has been a kind of democratizing effect through the technology of facilitated abuse that is worse in the sense that we're getting more prevalence, but it may signal at least some possibilities that more people will understand it and that we will take it more seriously.
Thank you. Thinking about, getting people to understand what we mean by this. Erica, I know where you sit, you end up hearing so many stories from survivors and survivors who are dealing maybe not only with sex harassment, but with other kinds of sexual violence. Can you tell us sort of in lay people's terms, or maybe thinking about stories that you have heard, what are some of the ways that this kind of abuse presents for people?
Yeah, we hear stories all the time from the coalitions and the local programs that we're working with. We hear stories both about how offenders are misusing technology and manipulating technology as a form of abuse, but also how they manipulate technology to cover up abuse and sexual assault. So I think that's another important piece of it. Some of the examples, some of the more common, we could spend all day just talking about the examples, but some of the most common examples that we are hearing about are using online platforms or cell phones, devices, text messaging, whatever, to send repeat, explicit, threatening, and harassing messages, threatening to share or sharing intimate images without consent. And of course, that does include actual images or fake images that have been created, accessing and distributing personally identifying information about the person, what is known as doxing. We hear a lot of concerns about that. And then there's also, I think, a broader concern too about anonymously posting sexually explicit content about the person. These could be suggestions about how the person might be in bed, or the things that the poster would like to do to the person. And sometimes the person posting this is known, and sometimes they're anonymous. And in either case, that behavior can feel degrading and violating, and very much and very scary to the person who it's about. And I think it's also really important to note that in many of these cases, one of the concerns there is that any of these behaviors that are happening online or through devices can lead to offline sexual violence. And that is often very much a concern that people are having.
One of the things that has struck me in talking to survivors who experience some of what you're talking about, getting messages, with things about what the other person wants to do to them, or images, this sort of thing, is that it's such an invasion of privacy. I think, people have this sort of popular idea of workplace sex harassment as being something that happens in an office. But with this kind of abuse, it can be following you everywhere you go. Can you talk to us a little bit about that part of it? What it might feel like for a survivor to be dealing with this type of abuse?
Yeah, I think that for survivors, it can be incredibly terrifying, and they can feel very much trapped, as Marianne had started to say too, that survivors feel like there's not many options. It's something that they can't necessarily get away from. There's many instances where survivors express that the use of technology and some of these tactics can feel very much like an additional layer of trauma added on, because it's hard to get away from and ignore and try to move past an assault or something that has happened when it is documented and it's been posted online, and so many people have witnessed it, and maybe people have seen it. That is a very hard thing for survivors to be able to try to overcome and deal with. It kind of extends some of that trauma that people are feeling. And like I said before, that there's always a significant concern of even online behaviors that are often very much minimized by people in their lives, by friends, by families, by employers, by law enforcement. Those if the behaviors are strictly online, or harassing text messages, or messages that are coming through a gaming platform, something like that, they can often be minimized. And there's no intervention and no real support to the person until it kind of escalates and comes into a real world and becomes an offline assault. So it's really critical that we always take these things seriously right from the beginning, and we trust survivors in the concerns and the fear that they're feeling, and not just wait for that to happen. Because I think we've heard from a lot of survivors that they feel like they're sitting in that space, that everyone is just waiting for something worse to happen before they're going to take action, before they're going to believe them and do more. So there's a significant amount of overlap with sex harassment, workplace harassment, and sexual violence in general. Some of the other tactics of misusing and manipulating technology in a more broader sense could include using online communities and platforms or gaming to groom victims, capturing images and content of sexual activity without consent. There's internet-based sex trafficking. There's misusing access to databases that somebody might have in a professional space to gather information. We've seen several cases where somebody has been impersonated online very specifically in order to facilitate an offline sexual assault, and taking photos, not just of the person intimately, but of an actual sexual assault and posting that. And then there's also examples of tampering with surveillance cameras, tampering with electronic content in order to cover up abuse. And I think the other piece too is that we see is that there's also a lot of additional online harassment that can occur not just by the initial perpetrator or perpetrators, but by the masses in comment sections of articles in social media. And that can have such a chilling effect on survivors and really have people hesitate to even come forward. So those are all things that we hear. In terms of the workplace specifically, I know you wanted to address on, I think that there are very similar behaviors and technologies. You may see somebody sending those harassing messages just on a different type of platform. There might be internal to the company communication platforms that are being used. There may be cases where coworkers have set up hidden cameras when there still are shared spaces. That is still happening. And colleagues also may have access to things that people who are not working in your agency have access to. They may have access to the office security camera footage. They have access to personnel files to be able to gather information on you. And of course, there are situations where technology is part of a tactic to hurt someone after they have declined someone's sexual advances. And this could include posting embarrassing content about them or getting into their files to even destroy their work product. So unfortunately, I think abusers get really creative in how to harm somebody, and all of these involve technology.
Thank you. Marianne, I know one of the main areas of your expertise has to do with non-consensual pornography. What should we know about the way that non-consensual pornography is experienced by survivors?
Right. So like with all these other forms of abuse, or at least with most of them, non-consensual pornography existed before social media. It existed before many of the advanced forms of technology we have now. And still people can do things like take actual DVDs or sex tapes or actual photographs and distribute those. And so it isn't just a matter of using advanced technology, but the advancement of technology has made it so much easier for this kind of content to be created and to proliferate and to be distributed. And when we're talking specifically about private, intimate images that are distributed without consent, survivors are going to have a spectrum of responses to this, including things like body shame, feeling as though that they should feel humiliated by what has been exposed to the public, all the way to suicidal feelings and everything in between. So the sense that you become reduced to the most private, intimate moment of your life, or to one moment that you didn't even know was being seen by anyone else. And that, especially for women, it is very difficult to disentangle sexual identity from anything else. We know that when people see women sexually, it's hard for them to see them as anything else. And so the impact of a topless photo or a sex tape when it comes to a woman being taken seriously in the workplace or in an educational environment, the impact is tremendous because of our backwards stereotypes about women and sexuality and sexual behavior. And so women feel very ashamed very often in these situations and feel like they can't go anywhere. They can't show their face at the grocery store, at their place of work, because they have to wonder who's seen me naked, essentially. We've seen that there was a phrase that Erica used, the chilling effect, not just in the sense of being afraid to report, although that's a big part of it, right? Because when you've got a form of abuse that exposes something that you want to keep private, telling anyone around about it, whether that's police or whether that's a lawyer or whether that's even your family or friends, is humiliating and difficult and counterintuitive because you don't want more people to see that material. But beyond just the chilling effect in terms of talking about it, there's a chilling effect of everything you do. It's harder for you to speak up at work. It's harder for you to contribute to your government. It's harder for you to entertain political ambitions because you know this is going to be used against you. You have this full gamut of responses, from just the sheer sense of loss of privacy and autonomy, that people are allowed to see you naked without your consent, to feeling as though you will never be more than a pornographic search result in a Google search engine, and how that brings many women, especially younger women, to feel as though things will never get better, which is tragically why we've seen a number of victims commit suicide. So it's everything that it feels inescapable in that sense, that there's nothing about your family relationships or your professional relationships or your educational opportunities or your ambitions for yourself. None of it is untouched by the fact that these images exist and are out there beyond your control.
Thank you. Carrie, from seeing cases that you have brought to our attention at the Time's Up Legal Defense Fund, from reading your book, from reading news stories about your work, have learned a lot about creative civil claims that are available to address this kind of abuse. Can you talk to us about that? What are some civil legal claims that are available to address the kinds of things that Marianne and Erica have been telling us about?
Sure. So, I mean, when we talk about civil claims, I want all the viewers to, if you get a case like this, to not just jump to civil remedies, because a lot of clients that will come to you will have different priorities. They might want the stalking or the non-consensual porn to just stop. That might be their only goal. They might want it taken down from whatever social media platform or website that it's on. They might be worried about their search engine results if when you type your name in, that's all that comes up. They might need an order of protection. They might, if they go to school with the offender, their priority might be for that person to be expelled or for, to switch schools. Like there's a lot of triaging. If they're a coworker, it might be all about, using human resources to expose the offender, and then kind of really far down the line are the clients who are at the point where they can think about, financial remedies. And that's not usually the first thing that clients jump to. Although I think, we all have to accept and celebrate the fact that they should be seeking financial compensation for harms that they suffered whenever it's possible. And we should, always, think of that as a viable option. So, in our cases, like in New York, we just got last year a civil remedy for non-consensual porn, as Jessica and Sanctuary very much know, and Marianne was the mother of this law going back to 2013. Finally, in New York, it passed. A different version of this law, I will add. Marianne's version was didn't have some of the annoying elements that ours has. So we do have civil remedies now when it comes to non-consensual porn. Oftentimes, I use the intentional infliction of emotional distress remedy, but the offender isn't always the right person to be going after. Oftentimes the client is desperately scared of them, or they're completely uncontrollable, relentless, obsessive people that you don't want to engage in litigation. They will, especially if they're pro se, they're going to make your life miserable with all these ridiculous, pleadings and unnecessary motion practice. But sometimes there's there are other entities to go after. Our non-consensual porn law in New York officially determines that being a victim of non-consensual porn makes you a domestic violence survivor. And we have laws in New York that then say that your workplace has to give you all these protections as a domestic violence survivor, and they can't discriminate against you if you are one. And they have to provide accommodations for you, and they can't retaliate. So sometimes when the offender works with the victim, or the offender is using the workplace to try to injure the victim, then you can you can go after the workplace. We had a case where we've had a lot of workplace cases where one case, the ex-boyfriend just created this dossier about his ex-girlfriend who was about to become an associate at a big law firm. And then he handed it to the law firm, and she ended up losing her offer. In another case, we had a hidden camera in our client's workplace bathroom, and they found like the drive that had months of all the employees going to the bathroom. Another case was one of our clients was being photographed at work, fully clothed, but then somebody was anonymously putting that onto Twitter. And so there, the focus of that case was an investigation. So remedies can include Title VII and also Title IX if it's happening at school, which Jessica is a total expert on.
Carrie, some of the work that you have done that was completely new to me was the work that you've done to take images down once they've already been sort of released out into the cybersphere. Can you talk to us a little bit about that? I imagine that could be really new for a lot of folks listening in.
Sure. So back when I started my law firm in 2013, really the only way to get naked pictures that were non-consensually published off the internet was using IP law, using the Digital Millennial Copyright Act to send the website a notice saying that there's infringing material on their website. And that really only applies to cases where the victim actually owns the copyright, so mostly selfies. It doesn't work if you were photographed without your consent or with your consent by somebody else. And so it was really a very narrow avenue. But then in 2015, we started getting domino effect, a lot of social media and big tech creating policies like for removing content. Up until then, it was completely arbitrary whether or not they would even remove content off of Twitter or Facebook, and it still often is a struggle. And we also had Google that created, a policy where they would sever the link and have it suppress it from a person's Google search engine results and Google image. But I mean, can you imagine, like, up until really recently, this stuff actually was super available, and Google was providing like a super fast highway to this material through its just automatic algorithms. So fortunately now, most of the platforms, you can just go on them to their forums and get it removed. Same with porn sites. Porn sites are a go-to place for publishing non-consensual pornography. And if you go to a couple big ones, then it's like, as soon as it's up there, then it's up, at 20 other sites, and it just spreads really fast. But like Pornhub has a very good policy that they, in my experience, are very good at just trusting victims that it is non-consensual porn. So, I mean, and, a lot of it's just asking, but it is, there isn't like a magical tool. It is just brute force, just having, I have an employee who almost her entire job is just notice takedown requests for clients.
Marianne, one of the many interesting things that you have done is work with the Uniform Law Commission's Uniform Law on Non-Consensual Pornography. With that experience in mind, can you talk a bit about what the limitations are of civil remedies that are available to challenge non-consensual pornography?
Yes, and I want to start out by saying I think everyone who works in this space just owes such a debt of gratitude to attorneys like Carrie, because without people like that at the front lines to try to get victims that they need, I mean, this really there really wasn't any recourse for victims many years ago, and so this is a tremendous development, and it's been incredibly brave path that Carrie has forged for herself and that many people are now following. But all the things that she's just described about the difficulty in civil remedies, would want to back up and say there's no remedy that actually works well for survivors, because the kind of harm that is imposed by non-consensual pornography is irreparable. There's no way to make a person whole after something like this has been done to them. There's only a question of sort of mitigating the harm that has actually been imposed, and trying to maybe compensate in some way for other types of harms that then flow from the non-consensual pornography, including losing your job or having to relocate or having years of therapy. So all of this, we need every tool that's possible to try to address this. But what it means is that civil remedies put an incredible burden on the victim. That is to say, it is up to victims to find attorneys like Carrie, and hopefully be able to either know that exists as an option, be able to have the kind of not only actual resources you need to pay for a lawyer, but to have the kind of cultural resources to know that that's the kind of thing you could even do, and that it's worth it for you to do, and that you find a good attorney that can actually get some things done, as opposed to, unfortunately, any number of attorneys who are there to take your money and not to help you. So these are all really big concerns. And so at the same time that it's absolutely vital that we have good civil remedies that are clear and in place and that victims can have access to, we also have to think about all the ways that is limiting, because it's only going to be a modestly good outcome for certain victims. Now, the criminal path is a different one, right? It doesn't require that you have an attorney, and one could argue that it is a necessary recognition on the part of society to classify this kind of abuse as a harm not just to individuals, but to society as a whole, which is what we should be thinking of when we think of what is classified as a crime, instead of only a civil violation. The problem there, of course, is that, as Carrie was saying, victims want very different things. Very often what they want more than anything else is just for the images to come down. A lot of them aren't interested in jailing the perpetrator or going through a long courtroom process. Who wants to go through a courtroom process where you have to testify to the darkest days that you've gone through, and to have to look at a giant screen where your images are going to be shown to a jury? It has its own deeply troubling requirements that it has. The value of the criminal route, though, is again that symbolic idea of saying this is something that is so harmful that it is something society should consider to be a crime, and that we hope that it would be the thing that deters people from engaging in this kind of behavior to begin with. There's every single non-consensual pornography case that goes forward is a failure of our system to not deter people from engaging in this behavior to begin with. When the Cyber Civil Rights Initiative, which is the organization that I'm now president of and that Carrie serves on the advisory board of, did a study into perpetration and victimization, one of the questions was, what would have you, if you have engaged in this type of behavior, what would have stopped you? And the answer overwhelmingly was criminal penalties. Not knowing how much this was going to hurt the victim, not maybe being sued, not any of those things. It was, if I thought I could go to jail, I wouldn't have done it. And that, unfortunately, is what makes us think that that's going to be an essential component of trying to change social norms around this kind of behavior. Because the real question we all have to ask is, why do people do this? And how can we get them to stop? Not just, what do we do once they do it? Because I think most survivors will tell you, your life is never going to be the same, even if you have a great lawyer like Carrie, even if you have a good result in the criminal justice system. It's not the same as the life you would have had this never happened to you. So the limitations, I think, of the civil approach are so much of the burden is on victims. There's so much for them to navigate in addition to all the trauma that they're experiencing. Many of those things are also replicated through the criminal justice system, and it has its own kinds of drawbacks, and we have to worry about the racial and class implications of the criminal justice system, because that's always an issue too. But it really is, I think, important to think about the individual versus the broader structural questions here. Non-consensual pornography is both a crime and a harm done to individual victims, but it's also a societal structural problem that needs structural responses, and it needs, we need to leverage everything we've got: the tech industry, law enforcement, private attorneys. All of it has to be leveraged to try to discourage this kind of behavior from happening to begin with. And so we've been really excited to see in the last few years that there's been some movement, as Carrie mentioned. Now Google actually has a policy against this, as do most of the major tech companies. Now, they didn't come up with that on their own, right? It was the advocacy of people like Holly Jacobs, who founded the Cyber Civil Rights Initiative, the work that the CCRI did, the work that Carrie has done to really just show up every day and try to tell these companies to take this seriously, that got them to finally ban this content. And we'd like to see them doing a lot more in terms of giving us data about how many reports do you get, which ones do you honor, which ones do you not? Are you sure that these are systems of notice and takedown that that victims can easily navigate on their own without having to hire a lawyer, because we want to be able to empower victims to be able to help themselves as much as possible. So the limitations are extraordinary. There's also the whole question about how so much of our harassment law, both in civil and criminal terms, rests on a notion of one-to-one contact, right? Someone does this to someone else with the explicit intent to harm them, which does describe a lot of non-consensual pornography, but also not a lot of, but doesn't describe a lot of the rest. As panelists have already mentioned, the abuse of women, sexual harassment, is a spectator sport. It is not always the angry ex who's out to destroy his partner's life. It's also the person who's sitting behind the keyboard thinking, I don't care if this person's life is destroyed. I'd like the idea of sharing nude photos because it makes me seem like a bigger deal than I am. It makes me seem like I've got some sort of cachet in my society. So we have to grapple with the fact that our existing law is way too focused on just the individual perpetrator who is explicitly telling people, I'm doing this to hurt someone. And we have to start thinking about all the people who perpetrate this because they just don't recognize women in particular as equal human beings that have dignity and rights of autonomy.
Thank you. I love the framing of this as a societal problem, and one that we need many different paths to address. I feel like we could go and talk about that for so long. I want to turn now to focusing on one of the tools in all of those paths that we could use to approach this problem, which is litigation. And I'd like to let Carrie and Jessica, our litigators on the panel, share with us some of their experiences. I think I'll start with Carrie. Carrie, you have had a number of really interesting cases using litigation to tackle these kinds of problems. Can you share with us some of your stories?
Yeah, sure. So, I mean, again, like our law in New York State for civil remedies relating to non-consensual porn is brand new, and very few of my clients want to go down that route. So most of my cases, that have gone into litigation, are some other fact pattern that involves a third-party defendant. So we had a case where our 13-year-old client was raped outside of her school, and then the video of it that he took then was circulated all around the 8th grade in Brooklyn, where she went to school. And the school responded by kind of gathering some of the boys who were distributing it and making fun of her and doing physical gestures, mocking her. And they had everybody erase the material. And then they brought my client's mother in, who barely speaks a word of English, and told my client's mother that she needed to just keep her daughter at home because her daughter's her daughter's presence at school was causing the picture to continue to circulate. And then they just basically left my client for dead. They didn't follow up with her. They didn't come, give her homework. They just she was out of sight, out of mind. So in that case, we, had a Title IX case against New York City Department of Ed. And, 4 years later, it finally settled. It was one of 3 cases that we had against them, all where they had discriminated against girls of color who had been victims of sexual violence and robbed them of their education. In one case, suspended the victim. So that's a case. One of our cases, one of my big cases right now, also involves a child, an 11-year-old, who was targeted and blackmailed into providing and producing some really upsetting material that then the offender continued to blackmail her to get her to produce more material, and then got her to give him the passwords to her social media things, and then as her sent the material around to her friends and family. Some other cases, we have a well-known case where it's a different kind of harassment, where, but again, tech facilitated, where our client was being impersonated on the gay dating site Grindr, and his ex was creating all these accounts and guiding all these unsuspecting men to our client's home and to his job, and he'd reported to the police 10 times and had an order of protection, and nothing mattered. And so that case ended up being against Grindr because 1,200 visitors came and they were refusing to help him in any way. But most of the litigation really, when it comes to non-consensual porn, are family court orders of protection. I mean, they're the most powerful way to get someone to go away. And, within, the same day, you can go to court. You don't even have to have an attorney, and walk out with an order of protection. And it usually takes, even if your case is being taken seriously, if you go to the police, it can take weeks or months for them to actually make an arrest, if they do at all. But they're much more keen on violations of order of protections. And so if there's a violation of an order of protection, even if they haven't arrested on the underlying thing that the victim may have already reported to the police, they often will arrest for the new crime of violating an OP.
Thank you. That seems like a great segue to Jessica. Jessica, I know that you've done a lot of work in the sort of world that Carrie was just talking about, orders of protection and other types of related actions. Can you share with us some of the litigation that you've had having to do with tech-assisted sex harassment?
Absolutely. So, the way that I approach these cases is often from either an order of protection side of a survivor who's seeking an order of protection, or from a survivor who is contemplating as their pathway to safety and justice, the criminal justice system. Because I am a former prosecutor, now working at Sanctuary for Families, where I am an attorney advocate. And so I see a lot of tech facilitated abuse in many different ways. This could be in an intimate partner violence context, where technology is used to exert power and control. In one of my cases, a survivor was given an ultimatum. She had fled her abusive partner, and she was in a confidential address, and she was given the choice. This was her choice. She could either disclose her address and put her physical safety at risk, or he would release her intimate videos. So we had to make that really difficult choice of what we were going to do and how we were going to safety plan around that. We have seen cases where survivors are coerced and threatened out of seeking custody of their children for fear that their abuser will send their intimate photos or videos to the judge in that family court case. Using this as a way to keep survivors, complacent and compliant and in the relationship. And as Carrie said, an order of protection can really go a long way, because we have had a lot of success in actually getting the orders of protection in family court to specifically state that the respondent or the perpetrator is prohibited from transmitting, disseminating, or threatening to do the same, or to create fake accounts, as Carrie was talking about. Over the summer, we even got creative and had, since the pandemic has gotten everyone online, much of the abuse and harassment we're seeing is online. So, we were dealing with a survivor whose abuser was making disparaging remarks, really disgusting and vile remarks on her professional GoFundMe page, which was starting to really affect her business. And so we asked for that to be included specifically in the order of protection through family court, which we were successful in. One of the things that I have really noticed, having come from a criminal justice background and now dealing with a lot of family court, is that orders of protection in family court are much more customizable. It is very, very difficult to get creative conditions included on criminal OPs, which is one of the frustrations I deal with daily now that I've left the criminal justice system. But we see a lot of other ways that abuse via technology has been used. I often saw this as a prelude to commercial sexual exploitation when I was at the DA's office, when I was investigating cases that had a trafficking element to it. And I would often see, especially my younger victims, because I was in the Child Abuse and Sex Crimes Bureau, so I was dealing with child victims mostly, who would get a message on Instagram asking them to be a model, right? And that's how usually it came around. Oh, I have these jeans, you would love them, they're so great. Come over, we'll do a photo shoot. And then, oh, maybe you can lose the jacket. Oh, maybe you can take your top off. And then, just as Carrie was talking about, using that to coerce into not only more sexually explicit photos, but actually commercial sexual exploitation and beginning to commodify their bodies. So we've seen that a lot. We, as you know, as Carrie mentioned, videos of sexual assaults that have then become viral videos, but not just that, using technology in really innocuous ways. So I had a case where a camera was used as a spy cam app, which allowed the camera to continue to record even when it went to sleep. And it was left in my victim's room, who was a minor, and videoed her while she changed and undressed. A lot of these are crimes. So that's the crime of unlawful surveillance, which is actually a felony. And so we really do, I am helping a lot of survivors to actually report and go through criminal justice cases, whether it is unlawful surveillance or the new non-consensual pornography cases, or something like identity theft, which is used when people make fake accounts. Actually, the abuser in the case that Carrie was mentioning with Grindr, he was actually convicted of identity theft, that abuser, recently. He took a plea to that. And I was actually, speaking with a prosecutor who's a friend of mine, and it was so difficult to even get that conviction, even though it was so clear he'd been making all of these accounts. And identity theft is one of those that nobody thinks about ever when we're talking about, non-consensual pornography or gender violence in general. But if you really are creative, there is a lot in the penal law you can use. The crime of coercion in New York is another one, which many states have. And so there are a lot of ways, but we have to work to help survivors to do this carefully and safely, which is one of the biggest reasons I've done so much criminal justice advocacy since leaving the DA's office.
Thank you. I love that sort of call to be creative and thinking about what kinds of claims and what kinds of laws you can use, and that you have your foot sort of in the criminal justice world and now the civil world. It's such a unique perspective that you're bringing to this work. I would like to ask this question to both of you, but I'll start with you, Carrie. What practical advice would you give to the lawyers who are listening in today and thinking about representing individuals who are facing this kind of abuse?
I think my first bit of advice for lawyers is to just take your lawyer hat off when you have these cases and kind of think about what your client's needs really are. A lot of times they won't know themselves what they need. They might come to your office saying, I want to sue, but really they might be really, really scared of their offender coming or sending naked pictures, or they might have a much more immediate need. It might be that they need immediate therapy because they're feeling suicidal, as Marianne mentioned. So I think you kind of have to think about the knee-jerk reaction to be like, okay, well, how do we look at this fact pattern, and what tort can we use? That inclination that we have, I think, can be put on pause for a bit. The other thing to think about is that when we are looking at how to respond to a situation, we get a lot of guidance from the offender, actually. And, you know, there are some offenders who are just on a complete rampage and are on a scorched earth attack and really don't have any anchors in their life, like a job or a family. And that's not the kind of person that you can send a cease and desist letter to. You know, and it would actually blow up in your client's face if you did. There are other people that, you know, may have raged in a moment of panic or something when their girlfriend broke up with them, and you know that person might respond well to a cease and desist. You know, I think just like thinking about all the different ways and tools that we have. You know, and the client's biggest concern might be that her job find out, and so the biggest priority might be to, you know, help her or him have a conversation with their job, or even, you know, draft the letter yourself, send it, you know, let them know that you're not going in as in an adversarial capacity, but you just want to let them know that your client's the victim of something and you really need their support if you know, if staff members start getting weird emails from X person, or, you know, can your IT department block emails from this address or something like that. That's my biggest piece of advice beyond, you know, the obvious, which is just, you know, role reverse, think about how it would feel if you were in the other person's shoes. I mean, most attorneys that are doing this kind of law and that are listening here are already in the business of thinking about people who've been horribly harmed, and so I know that they're already doing a lot of that. And also just like have your client screenshot everything. Screenshot everything is like number one.
That is a good segue to the next topic that I wanted you all to talk about. Jessica, I do want to hear your practical advice, but I want to move us into talking about what lawyers need to know about gathering and preserving evidence in these cases. And I know you have a lot to say about that. So I'd love for you to include that in your thoughts about practical advice. Before we do that, we have come to one of the moments that I'm going to give people the magic codes for the CLE. So you all want to take this down if you're going to be asking for CLE credit. And the first code is NWLC, like National Women's Law Center, 1112, like the date. So it's NWLC 1112. Going to say it one more time just to make sure that folks get it, although this is a very odd part of moderating this webinar. It's NWLC 1112. Make a note of that, keep it, you're going to need it to get the CLE credit. Okay, now we're going to keep going with the presentation. Jessica, can you talk to us about your practical advice for lawyers and start to tell us what kinds of things people need to know about gathering and preserving evidence in these cases?
Absolutely. So first, sort of talking about practical advice about how to sort of deal with these types of cases and how to really effectively incorporate all of the different professionals and partners that you can to really streamline these cases. One way is I would do what I call system mapping, best pathways to safety and justice. So that could be legal pathways, and it might also be non-legal pathways. And sort of building on what Carrie said is assessing first your client's needs and taking down, what trajectories would be best for that person. So for example, I met with a client who was in a very, very, very physically abusive relationship, who had absolutely could have gotten a criminal, case, could have reported very instant physical violence, also could have gotten an order of protection in family court. But when I met with her, what the most immediate need was that we realized is that this abuser was reading all of her text messages and had actually signed into her iCloud and was reading all of her messages, including those with me. So the most immediate need there was not to report to the police, not to get an order of protection, but rather to get her device screened so that we could find out where the problem was and actually safely remove it, which we did, right? So we system mapped. We then took over going down these different trajectories, right? So what would your case look like in the criminal justice system from start to finish? And what would it look like in the family court system? And what are the differences, right? What's the practical approaches to both of those? What can you get out of those? And what are you not going to get, right? So that we don't start down one or more pathways, which we shouldn't have begun from the beginning. And if a survivor had really been informed about what this was going to entail and what would have been the end result, maybe they would have said, so sorry, not for me, right? So another really important thing about this is to know your expertise. So as a former prosecutor, the criminal justice system is my bread and butter. And so I can speak at length about the criminal justice system and what that's going to look like for survivors. But where I'm not an expert is in civil remedies. And so I don't purport to be an expert in those. And I reach out to partners that I have who have that knowledge. I have had tons of phone calls with Carrie's firm. One of her associates, Annie, someone I call on the regular to discuss, is this a civil case? What would the claims be? Because I don't have to be an expert in anything. And I would never do wrong by my client by purporting to know things that I don't know. In the same way, I welcome folks who don't have the criminal justice expertise that I have to call me. Let me help and walk through a survivor so that we can talk on the macro and micro level of what that survivor might entail. I also encourage folks to try, if they can, if a criminal justice case or avenue is something that someone's interested in exploring, please try and think about approaching a pre-arrest investigation report or pathway, which really entails working with the district attorney's office before an arrest is made and having an interview with an ADA and a police officer so that we are doing the most trauma-informed process, so that there is not multiple conversations that the survivor has to have, multiple persons that this video has to be shown to. I had a case where I work, as Carrie mentioned, in a lot of Title IX cases with a lot of college students who met a person on Tinder and had consensual sex with them. When she decided to break up with him, he let her know, in fact, that he had taken videos of them having sex without her knowledge. And then he ridiculed her and said she would never tell the police because she was a little person and she couldn't reach the desk. She was mortified, she was humiliated, and the idea of walking into a police precinct and going up to a desk sergeant and showing a video of her having sex was horrifying. And she's not wrong about that. And so we got on the phone with the district attorney's office that day, and she met with an ADA and a detective one day in the DA's office, not in a precinct, and she only had to show that video once. The other amazing thing about pre-arrest investigations involved. It allows for them to do subpoenas. It allows for them to do preservation requests to actually make it so that these accounts can't, if it's a Facebook or an Instagram, can't be deleted. It allows for them to do search warrants. It allows for the investigation up front so that we're not scrambling to make an arrest. We're doing it in a trauma-informed way. Going off to evidence. One of the best things that you as an attorney can do is to help along that process by preserving evidence. But there's a way to do that that's really helpful for law enforcement or any other civil, legal case. If you're taking screenshots, you want to do overlapping messages to preserve the continuity of the conversation. And what that means is the last message in screenshot 1 needs to be the first message in screenshot 2. Is that annoying? Absolutely. But is it necessary? You bet. Because what's a defense attorney going to say? And I don't mean that in a bad way. My father is a defense attorney and I love them very much. But what's a defense attorney going to say? That there's missing messages, right? We're going to stop all of that. We're going to have the continuity of the conversation. You want to be making, pulling the message over so that you have the date and timestamp. If it's a really long message thread, as many of these are, because sometimes this is happening between folks who've been together for a long time, consider screen recording the threads of the messages. So a lot of iPhones can do that. You can actually scroll through the messages really slowly and actually take a video on your phone of the messages, right? So now you don't have to do 400 text messages. You have to do a slow screen record. And every so often you pull the message to the side, you get a date and timestamp. We also want to not keep all of our evidence on one place. Right? Because everyone keeps it on their cell phone. And what happens to cell phones? They fall in the toilet, they break, they go missing. I lose my cell phone every other day. So we want to keep those messages in a safe place. And going one step further, for some folks, we're documenting while we're still in the relationship, which is very dangerous, actually. So you want to not always keep it on your phone, but maybe on a USB, right? That you can keep safely somewhere. Another option is if you're taking screenshots on your iPhone, there's a way to click edit photo. You can then crop and zoom in and save the photo in that way. that shows, it will allow it to not show what the image is. So you can like zoom in on like a piece of my arm, which will just show the photo as black. And then when you go back into the photo, you can push edit and revert to original, and it'll go back to the original image. So that allows you to safely document, screenshots or photos of injuries or anything else that you might have without perhaps your partner, who might be looking at your phone, knowing. The other thing that might be really helpful is if there's an account that is posting a lot of these, harassing messages or, intimate photos. And it's not a post that says, or a user handle that says Jessica Morak. It might be something that's a nickname or something that we don't know what it's about. Considering doing, screenshotting, and Carrie said screenshot everything, but consider screenshotting as well control posts, right? Instead of just screenshotting the, messages that are harassing, consider going back a little bit and doing a control post of something that is uniquely about that offender, or a photo that offender put up of them with their friends, right? And that allows for you to then authenticate that they are in fact that person without having to first get an IP address or subscriber information, which the district attorney's office might do, but at least at the beginning, when the law enforcement inevitably says, well, how do we know it's this person? Well, here's 3 months ago or 2 weeks ago, they posted a picture of them fishing. I don't know if anyone goes fishing anymore, but I don't know why that came to me. So there are a lot of really great things that, advocates and attorneys can do before you even get to reporting to anyone, which I like to call pre-arrest packages. Come with your pre-arrest package all tied up in a bow. And if anyone has questions on how to do that, I call me, text me, email me, and we can talk it through so that we can really make sure that we're supporting that survivor in the best way possible.
Thank you, Jessica. And that's so generous for you to offer up that people can contact you with questions. I wanted to turn it over to Erica. Erica, I know that at the Safety Net Project, where you are, you all produce all kinds of resources for different audiences, advocates, judges, attorneys, and I'd love to have you tell folks what is out there. What kinds of things should people be looking at if they want to get more information, other than calling Jessica, to think about what they need to do to preserve evidence in these cases?
Yeah, thank you. I love so many of the examples that Jessica gave. There's such great concrete examples of how to collect evidence. And we have a lot of that too in some of the resources that we've started to create and pull together. And I'm totally making a note to probably connect with Jessica too. And like, are there other things? Because the technology changes so rapidly. There's always some other way and a different way to like capture a screenshot. So first and foremost, we always want to make sure that we're trying to make things easy and accessible to survivors. Not everybody is comfortable with text messages or with technology. Not everybody is comfortable with understanding how to do a screenshot. So in our survivor toolkit, which I should back up and first say that we have a ton of resources on techsafety.org, which you can also get to from NADV.org. But techsafety.org, we have a survivor toolkit where we have information about documentation. We have videos to show simple ways to capture the screen, to take a screenshot, so that people really try to understand what that means when we say that. We have a documentation log that we constantly point to for survivors to use. We are big advocates for creating documentation logs, and we often suggest that to survivors even when they are saying that they're not really ready. They're not ready to engage with an attorney or with the criminal justice system or anybody because they're not sure what they want to have happen. And as Carrie and Jessica both have mentioned, sometimes the immediate priority in that moment is just making sure that they get that whoever is spying on their phone or their acts out of their device, right? They want to stop that immediate spying. They want to stop the potential access to the security system that they had jointly set up in their home, even though the person is no longer there. These kind of immediate things that can be a safety issue, that's their top priority. And even in those scenarios, we are encouraging the creation of a documentation log. And that is is because so many situations, the survivor is in a space where they are not necessarily sure of what the abusive person is doing. They're not sure of what technology is being misused. They just know that the person knows too much. They know that they know where they are going, they know what they wore, they know the text message that they sent someone, but they don't know exactly how the abuser has gotten those things or the perpetrator has gotten that information. And a documentation log can start to show patterns in those behaviors. We have seen cases where those documentation logs have identified patterns in behaviors that have allowed for investigations to start, that have pointed to consistency in those behaviors. It might even be like, the person realizing after a week of taking those documentation logs, realizing the person is sending this bulk of harassing messages comes in within this time frame on these 3 days of the week. And what does that mean? What does that mean? And if the person's known, which in most cases they are, then that might be. There was a case where they identified those time frames as when the person took their breaks at work. And then they took that information to then go to the workplace and look at the surveillance cameras. And the person was, during their break, accessing a work computer that they were not actually allowed to use, but they were doing that unknowingly to anybody else in the workspace. And they did that because they were trying to hide their tracks, and not using their work device and their workstation. But that opened up being able to know which device to get access to, which device to search, and then that was able to point them back to and identify that in fact was the person who was sending it, and they couldn't hide and say that it wasn't them, because unfortunately these tools that allow people to hide behind the technology and make themselves anonymous, these tools are getting more use. So it's making it harder to identify the user, even when the survivor knows who is likely behind it. So the documentation logs can help with those things, can help identify those patterns that can be really incredibly useful to the person. So we have those materials on the website. We also have a whole bunch of materials that are meant for people within the legal profession. We have a legal systems toolkit, and in there we have a piece on evidence collection tips for civil attorneys. We rolled out an entire campaign and curriculum to train judges, where we have, really interesting exercises, like, teaching judges how to read an entire text message thread made out of emojis, because that is the world we live in. And if we don't know what emojis are saying, what somebody's communicating when they're sending emojis to another person, that threatening message is very easily minimized if the person doesn't know how to read that and what it's implying and saying. So, we really want to think through how to increase capacity and understanding of the technologies for whether that's survivors in terms of helping them to understand how to collect that evidence, how to document in the best way, and on various different devices and in the safest way. I also have to say, earlier this year, we launched our evidence collection and documentation app. It's called DocuSafe, and it is a free app that is meant to help survivors of abuse to collect, store, and then securely share evidence of abuse. So people can use this to log individual incidents with dates and information to be able to provide context. And then they can add in things like screenshots or video documentation of harassing messages, social media posts, call logs, things like that, and other behaviors. So there's that tool that we launched and we hope is really useful. We're also always open to feedback. So if you are ever using this with a survivor and you think that there's a functionality or feature that would be useful, we want to know that. So please let us know. And I think the other thing that's been coming to my mind too is just thinking about meeting survivors where they are. And that is going to be so important. Like as Carrie said, taking off your immediate professional hat and really really just sitting with a survivor and thinking about where they're coming at this from, it's so important to do that and to consider how the trauma is impacting the person. One thing that, I think is always so important when we think about this intersection is the populations of people who are experiencing significantly high rates of sexual assault, of online harassment, women of color, gamers specifically. Like, there's this huge amount of assaults and attacks online that are perpetrated specifically targeting women of color gamers and women of color generally online. But also, what comes to my mind is women with disabilities are very, have extremely high numbers of sexual assault and sexual harassment. And I think that's a really interesting topic for us to think critically about, because there's so many, unfortunately, so many misconceptions in our society about the sexuality of people with disabilities, that often many people with significant disabilities have grown up with in isolation, without the same kind of education and information about sex and sexuality that many people without disabilities get. And because people have tried to shelter them from that information, it's content that people often then get online. So then when it comes time to disclose what has happened, to disclose the type of abuse that they've endured, it can be something that they explain in a very explicit way, because that's the language that they've learned to describe those acts. And that we've seen so many situations where they don't get the best reaction to that, because people are not considering that where that language is coming from. If people are learning about sex and sexual activity from pornography, then that is how they're going to use, that's the language they're going to use in those disclosures when they're reaching out and getting help, or asking for help. And also, and then I'll move on, but there's also very different technology that is used in that population, for example. So the technology needs, the technology evidence collection needs, all of that changes so dramatically. And so that's just a really important piece for us to always remember about the importance of meeting people where they are and considering the very unique experiences that they might be having, depending on who they are and the spaces that they're in online space, in the online world.
Thank you. I was so excited and impressed to hear about all the resources that are available. And for folks tuning in, there are links to many, if not all, of the resources that Erica just mentioned in the CLE materials that are provided. So take a look at that, go to their website. Erica, will you tell us the main website that people should go to? There was a question in the chat about that.
Yes, and I can write that in there too. It's techsafety.org.
Great. Okay, so now people have been sending in terrific questions, and I am going to read from them and see how many of them we can get through. I also realized that I was remiss in not introducing my lovely colleague Anna Block to folks who have been seeing her. She is hiding behind this terrific photograph, but she is one of the team members of the Time's Up Legal Defense Fund, and many of the reasons that this webinar is being successful today have to do with her. She has been following the questions, and I am going to turn to one of the first ones, really important question that we got from someone in the audience. I will read what she's written, which is this. Can you please speak to how this topic is affecting women of color? Specifically, if you've seen any way in which the law disproportionately fails to protect women of color, especially Black women and low-income women. I think probably all of you can speak to this. Who would like to take this one first?
I can say a couple of things about that. I think one sad short answer is that the law fails women of color across the board. And it's not an exception when it comes to questions of technologically based sexual harassment or sex harassment. So in addition to not taking the concerns of these communities seriously enough, there's also the mistrust often between, say, for instance, law enforcement and these communities for very good reasons. Many women of color hesitate to call the police for crimes or for other harms that they're experiencing because of Well, where should we start, right? Because of possible racist treatment, because of treatment of, let's say, for instance, their partners at the time, that they don't necessarily want this person to go to jail, and they don't certainly want this person to get shot. What they want is for the abuse to stop. So there's deep mistrust often between law enforcement and these communities. There's a long-standing historical trivialization and undermining of the concerns of these communities and actually hearing where they're coming from. And there does tend to be disproportionate targeting of these communities. So in the empirical work that we've done at the Cyber Civil Rights Initiative, we've seen disproportionate targeting of women of color, and particularly bisexual women, so sexual minorities, racial minorities. And there's also clearly a class component that comes into a lot of this too. Class in the very broad sense of meaning, again, not just whether or not you have financial resources, but whether or not it's ever been presented as a genuine option for you to go to the law, that the law sees you and that the law is going to help you. So certainly in the experiences that we've had, we have seen a disproportionate impact, and any number of factors that kind of combine to make it harder for women of color to get help when they need it.
And I'll add to that, the disproportionate treatment of girls of color versus white girls is staggering. When you're talking about minors and them reporting crimes and being believed. And even in courts, we've had cases where judges just, really lecture the girls for having, in one case, our client was a 16-year-old girl of color who'd been photographed without her consent. The offender was older, and then it was disseminated without her consent. And the judge gave her a lecture about, how pictures last forever. Well, she didn't even take it. In another case, our client's mother was, the client, it was my 11-year-old client, when they reported it to the police, just the most ghastly victimization I've ever, had as a client. The police told the mom that, she should see this not as a crime, but as a disciplinary moment. So there's so much shaming of girls of color that you don't see. And that happens at school, it happens in the criminal system, and it happens in the civil.
I would also just add that if anyone is interested in, there's a lot of incredible research and articles around this topic, but one that I found to be very interesting that was put out by Amnesty International called the Troll Report, actually did a look on Twitter about who was the subject of most online abuse. And it did find a staggeringly, actually 84% of Black women were more likely to be than white women were likely to be the recipients of problematic and abusive tweets, and women of color in general were 34% more likely to be mentioned in abusive tweets. And this is, this is like the online abuse that I feel even just the name troll tends to diminish and, sort of excuse the type of online bullying that we see so often. And calling it online bullying makes it seem like, these comments that are posted under articles or videos are something that we shouldn't be taking seriously because it's something we should just sort of roll off. They're trolls behind the computer screen, but they are abuse, they are violence, they're digital violence. And many of these offenders end up perpetrating other types of gender violence online and in real life. Often we have found that this abuse online, these comments, these trolls, which I sort of hate that word because again, it diminishes what they are. They're offenders. I'd much rather hear the word offender. But when we see that offense, oftentimes it is not just gender related, it is not just sexual related, but oftentimes it is race related. I think Erica's probably familiar with this, but at the conference that we had in October, we had the co-founder or the founder of Brown Girl Gamer Code, Brandy Javia, who spoke about how she had to create a safe space in the gaming industry for Black and brown women because there was none, and that the abuse that she faced while foraying into this gaming industry was not only because she was a woman, but in fact was, but because she was a Black or brown woman who dared to be in an industry that had never been occupied by anyone who looked like her. And so I applauded that organization, and I implore anyone to check it out. It is fantastic. And I'll put the Amnesty International link in the chat. I think it is really important that we stop thinking of these comments, under a YouTube video as trolls, but actually thinking of it as violence and abuse, because that's what it is.
Yeah, Jessica, if you could add the Brown Girl Gamer Code link when you add the amnesty, I think that would be helpful. My internet wasn't opening, but we had Brandy at our tech summit as well. And her information is phenomenal and really should be paid more attention to.
Great, thank you. Okay, I'm going to move on to another question that we've gotten from participants. I will just read this question directly. This person asks, we always struggle between preserving all ESI, electronically stored information, or relying on our client to preserve ESI that they think are relevant. In the former situation, we often end up with dilemmas on what to produce when discovery rolls around. In the latter situation, we end up wondering if we are going to be missing something. What are folks' thoughts on that?
I mean, I'm sort of a maximalist. I want to see everything. And I think if there's, I think it depends on the discovery demand. Like if it's, you can never, if you have litigation, you can never allow your client to delete stuff. So, if it doesn't really matter what you yourself have, it's what your client has. And so I think I want to see everything. And I don't want my client to delete anything. And even if there's content that's not flattering, in most of these cases, there's a very clear distinction between who the victim or survivor is and who the perpetrator is. And so even if there's content that's embarrassing or unflattering or could go to the integrity of your case, you still you need to know about it, and usually you need to hand it over if the discovery request shows that. In cases of sexual violence, at least in New York, there's law that protects, where you can get like a protective order for it, so that it's not part of the docket.
I would agree with Carrie. I also tend to be a maximalist, and I think that's because of coming from a prosecutor background. But especially you really have to consider what type of case your client or the survivor you're working with is sort of thinking about, right? So I often work with survivors who are thinking about the Title IX relief. And there is a lot of evidence that is asked for in those cases, and it's not bound by the discovery rules, right? So there aren't actually parameters around it. It's only ruled by the rule of relevancy, in fact. And so it's not actually a subjective relevancy, it's an objective relevancy standard. So that's really up to the Title IX investigators about, what kind of material is relevant, but it comes from much of the evidence might come from your advisee if you're working with a student who's going through that. And so, I always want to see everything first so that we can talk meaningfully about whether or not this is something that is relevant or not, or protected in some way. Just like Carrie was saying, in the Title IX system as well, prior sexual encounters with others is protected. Mental health concerns are protected and will not be included. But when you're talking about a criminal context, it's a whole different ballgame. And it really depends on the discovery laws in that state. In New York, our discovery laws are incredibly difficult and often are not survivor oriented. So there may be a ton of information that seems completely not relevant to the survivor, to the civil attorney, to the advocate, but in fact, it will be required that the prosecutor, if they know about it, has to give it over. And so you really want to be talking, again, I say, know your expertise, and make sure you're talking to partners and professionals so that you're not running afoul of any of those laws.
Thank you. Okay, I'm going to bring up another question that I think is really interesting and a hard one. So this person writes that they find that technologically based harassment is usually easier to prove because you have a record of it from texts and emails and postings and things like that. And this person asks, as we move to more tech-based communication, does this mean that there is likely to be less sexual harassment? What do folks think of this? I had been meaning to ask you all if you think that having more virtual communication in this time of pandemic, is this tied to less sex harassment? Sort of linked to what this person is bringing up. What do you all think? Is there a connection between more tech communication and a reduction in sex harassment?
Well, I mean, one of the things we're talking about today is that, tech abuse can be sexual harassment. And so if we're moving, more online, then, you're going to have more cases like Jeffrey Toobin, who's masturbating at a Zoom call, to his own colleagues, or it's going to take different forms. But I haven't seen a reduction. I think I think the first part of this question is like, I love it, because the evidence is the crime in a lot of these cases. The crime is the evidence, as the asker pointed out. And so with tech abuse, like, there is so much evidence. Every message, every text, every social media thing, it was sent from somewhere and it arrived from somewhere. And so these should be like dream cases. And what we're hoping for is that our law enforcers get to the point where they're excited about these cases, because there are clues to find them out, even with VPNs and masking IP addresses. Like, if you hunt hard enough, like, usually the offender messes up at some point. And so, I think in most of these cases, the offender is lashing out. They're not seeing this as a crime. They're not in control of themselves. And so they're not thinking like about the evidence when they're committing the crime. They're already thinking that they can get away with it, or that their victim is never going to go to the police or to the boss or get an order of protection.
I would also just add that, I think to what Carrie said, there is a lot of evidence, right? Because the crime is the technology, but in proof wise, sometimes it is just as difficult, if not more difficult. And it's based on a lack of understanding on the part of law enforcement to just understand the tech, or being able to, mask yourself. So anyone can get a spoofed number, right? You can get it from Google Voice or other apps, right? And those mask your phone number. And then you're going to have law enforcement that says, well, how do we know that that's that person? Whether you get, a spoofed email or a fake account, right? So it is very difficult. Also, a lot of these websites that host non-consensual pornography or these intimate images, they're based in other countries. So it is very, very difficult for law enforcement to, in fact, serve a subpoena on, countries that, are domains that are hosted in other countries. So that's a big problem that many law enforcement come up against when they try to bring these cases to trial. So that is one of the reasons that I have been, so increasingly pushing for pre-arrest investigations, because, in order to find out where something is hosted, to get that IP information, to preserve these accounts, you need to involve the district attorney's office in many cases, because you need to get preservation letters and subpoenas and search warrants. And that really requires a partnership with the DA's office before there's ever going to be an arrest made. And so I think it's definitely provable, but there are a lot of steps involved and not necessarily easier.
I just want to, echo everything that's been said, and to add a couple more things. Anecdotally, we have seen actually a pretty serious uptick since the beginning of the pandemic in terms of calls that come into our crisis helpline about non-consensual pornography, 37% increase in calls. So that's a pretty alarming statistic. But even beyond all that, in addition to all the things that have just been mentioned, you'd have to assume in some ways that having the proof means that everybody's going to see it as proof, right? A lot of people's perceptions about, for instance, police body cams was going to be that as soon as we have recordings of police brutality, then it's going to stop, right? Because people are going to be held accountable. And then you have to realize that just because certain people think that this is clear, this shows abuse, this shows harassment, it's amazing how people will look at the very same evidence and say, well, this proves that you are sexually promiscuous. This proves that you had it coming, right? So we can't assume that technology is going to get us out of this. If the same social norms are going to have these deeply embedded sexist, racist ideas about people's behaviors, then it isn't actually going to help that we have more and more proof, because that proof is simply going to be dismissed as further indication that the victim had it coming.
That is a very real world note to end on, I think. We are at time. I'm going to give folks who are paying attention for the CLE credit the final code. The final code is HSG, like Howell Schuster Goldberg, the law firm that is making it possible for us to give CLE credit. So it's HSG 1112, like the date. So it's HSG 1112. Write it down, keep it safe. You're going to need it to get the CLE credit. And thank you so much to our fantastic presenters. I learned a lot. This has been such an interesting conversation. We have had a record number of people tune in. So thank you to people for tuning in today and all your work with the Legal Network. And take good care, everyone. That's the end of our presentation.
Thank you.
Thanks.